Namaskar. Welcome in this live interactive teleconference of MBA in Healthcare and Hospital Management program. Today we are going to discuss about the Consumer Protection Act. As you are well aware that healthcare service is also one of the service which is the integral part of our day-to-day life. And here patient come to the hospital or any healthcare institute as a consumer. So the question is how to protect the interest of the consumer. Although there are many medical ethics which is taking care of the interest of the patient, but in the same time there are many laws of the country which is also protecting the patient or service oriented issues for the patient. One thing is important that the Consumer Protection Act in the different country are in different in nature. But here we India also we follow, and as a healthcare provider, as a healthcare manager, you must know that what are the rules and regulation of the Consumer Protection Act. So this is the very important topic, particularly not only for the exam point of view, but for day-to-day purpose as your livelihood, because you are here to provide a good quality of service as per the standard of the country. So here to discuss all this issue, we have a expert, Dr. Bidhan Das. Welcome you, sir, in this live sessions. And sir is having several decades of experience in this healthcare management program. And sir will brief you. And if you have any questions regarding this topic, you can ask the expert by telephone. The numbers are displayed on the screen and you can interact with the expert. So not wasting much time, here I would like to request sir to discuss about this topic.
Oh, thank you, Dr. Biplab. So first we'll discuss about the act proper and a little bit of history of those acts, the terms, various terms that we use in the act, because now we have to use legal terms. So that some terms we'll be definitely discussing, and of course salient features of the act, and of course implications for the healthcare professional, whether it is in the ambit of the act or not. So that we will discuss, and anything else that crops up on the. So the first principle of living or society is that thou shalt not injure thy neighbor. That means we should do no harm, to others, to anybody else. So first and foremost, we should not do any harm to the patient. So in this case, the patient is the receiver of care and we are the providers of care. So the least that we can do is do no harm. But over the period of time, this doctor-patient relationship has also changed the paradigm of provisioning of medical care. Maybe many factors: materialistic outlook, changing value systems, technological advancements, awareness and education on the part of the patient.
Yeah, aspiration as well.
Perceived dilution in accountability. So now, having mentioned all this, we need to have a legislation. So legislation means any act or passed by the Parliament or Bidhan Sabha is called a regulation, legislation. What is regulation? Where a punitive clause is added to the legislation is called a regulation. So difference between legislation and regulations is there. Now types of legislation
But here, sir, important is health in country like India is a concurrent list.
Yeah,
so
it is.
central regulations we are having different, and many
States,
states can have their own.
but commonly we have this biomedical waste, AERB. These are all regulations.
Yeah, Clinical Establishment
Clinical
Act.
Establishment Act. Yeah. So we had written the Clinical Establishment Act. Common minimum standards for various levels of hospitals.
Yeah.
So by and large,
It is almost
by and large, yeah. Situation prior to CPA was, when the CPA was not there or consumer protection was not there, it was filed under law of torts. So there was a law of tort under IPC or CRPC. So that was the compensation law of torts. So now there is a Consumer Protection Act. Even the IPC has gotten a new nomenclature in the recent past.
Yeah, yeah.
So that has been changed. So, what is the advantages and disadvantages? Disadvantages, these kind of legal procedures were very, very long, So, you can find a criminal defamation against a doctor also. When there is a permanent disfiguration in the form of a scar, a woman can file a case against the doctor. So, that comes under IPC, which will be almost like a non-bailable, on the part of the surgeon. So it can, you can get into that kind of problem. But after the Consumer Protection Act, the UN Assembly passed it in 1985, and in our country, that was CPA was passed by the Parliament in 1986. In the UN it was 85, and here it was 86. Well, it is a dynamic and a radical piece of welfare legislation respecting consumers all over the world and in our country also. Cheap and quick redressal mechanism, because once you pay for a services, then you pay for legal services, it becomes a very, very difficult. So very, very simple method of filing the case, and less expensive. You can do it yourself. You can may not engage a lawyer also. Now, what is the law? Law I have already mentioned. What is the law? What is a complaint? So the law defines these terms. Under section 2.1, an allegation shall constitute a complaint where the services mentioned in the complaint suffer from a deficiency in any regard. So you have promised me that you will be giving a services of this sum. Now, if there is a deficiency, then I can raise a complaint against that.
For example, you promised me to give 5 tablets, but you given me only 3 tablets. That is the one of the very crude way of
silly of But supposing you have come to a plastic surgeon and getting something done for your nose, for your lips, or for your skin, that result didn't yield the way it was promised to be done. So I can, sue you to that. Who is the complainant? Once we've defined what is a complaint, who can lodge a complaint? There is a complainant. Any consumer or consumers. Okay. Voluntary Consumer Association registered under Companies Act who makes a complaint is called a complainant. That is the law that who is defined what is a complainant. In case of the death of the consumer, the legal heir or representative can also file a
case
complaint. Who becomes what is a consumer? So under section 2.1d, any person who avails of any services for consideration which has been paid or promised to be paid, either fully, partially, or in the form of deferred payment, like insurance, So they can also file a case. But not in case of person avails it for commercial purposes.
Okay. Sir, in this context, suppose I am a surgeon and I am a plastic surgeon and I am giving you free service, and there is some kind of things. So is in this issue, can the person sue me?
The issue is that you may not have taken money from me, but you take money from others, and you are doing it in a hospital, so there's a good liability. I can file a case against you.
Okay.
Even if I have not paid you.
Yeah. But particularly in your case only, I said that total I am giving you free.
Even then.
Okay.
Yeah. So now there is a difference between a consumer, defined a consumer. Now we'll talk of the consideration. Consideration means fees or payment to the doctor or hospital. It may be done by the patient, guardian of that person. In case of death, the patient or his and his legal heir is also a consumer. So the law has defined who is a consumer, what is a consideration, and what is a fee. Service. What is a service? Service of any description which is made available to potential users, but does not include rendering service of any services free of charge or under the contract of personal service. Let us give an example of a organization. Let's say Steel Authority of India Limited, Coal India Limited. You are a doctor there, I am an employee there. In that organization, I cannot file a case to you.
Okay.
So that is the only respite. Because both of us are working for the same master.
Although I am a doctor, I may do some kind of maybe.
Yeah, I can file a case on the IPC, but not under consumer.
Okay.
Because I have not paid, because the employer, Coal India, or let's say They give the services, they give medicines to me, they give everything to me. So I have moved. And both of us have worked for the same master.
Same organization.
Master, yeah. So that is the only respite. Deficiency. What is a deficiency according to medical terms? Any fault, imperfection, shortcoming or inadequacy in quality, nature and manner of a performance of a medical service rendered by the person or the hospital. So this is a tricky term. Nature and manner. Even if I am rude to you as a doctor and you are offended or insulted or hurt.
And particularly this kind of are very subjective.
This is the law, so therefore there will be an issue. This is the law, you know. Consumer dispute occurs when a person against whom a complaint has been made denies this allegation. So there will be a dispute. Now you filed a complaint and I said, no, I have not done it. Then there will be a dispute. Then we will go to the court. Now what is a medical negligence? Falling short of reasonable medical care. Now the meaning of reasonable is, so you are an MBBS and MS with 5 years of experience. So your services or competency shall be compared with the MBBS and MS of 5 years experience, not with the
MBBS doctor.
And not with the MBBS MS with 20 years of experience.
Yeah.
So reasonable care is expected out of the experience and qualification. Yeah. Now, what are the objectives and reasons for this act? So better protection of the interest of consumers. You need to protect the rights of the consumer. It's hailed as a good act. To make provisions for constituting the consumer councils and other authorities in order to provide quick and cheap and easy remedy in terms of compensation, money. So compensation means then the doctor or service provider has to be indemnified. So they need to have an indemnity bond. So whether the employer pays for the indemnity bond or not, or the doctor individually does, is a separate issue.
Yeah.
But
they may have their own insurance also for that.
Either way, whatever is. Now, therefore, we need to have an understanding of the right of the consumer. In our case, it is the patient. The rights of patient. Right to safety, right to be informed, right to choose, right to be heard, right to be represented, and right to redress. Right to fair settlement of just claims. Right to consumer education. Right to acquire skills and knowledge to be an informed consumer throughout life. Right to a healthy environment to enhance quality of life. Right to basic needs. So these are the rights of a consumer, and more so in our case it's a patient. So patient has the right. But the problem is, if you give all the rights, then there will be some responsibilities. So then therefore you must have seen that hospitals would define the rights and at the same time
a responsibility also.
Do not litter the hospital. Follow the doctor's advice. Come to the follow-up clinics as advised by the treating physician. So and so forth. So these are the responsibilities, because patients many a times or most of the times would not follow the responsibility, but they are very mindful of their rights.
Yeah.
So rights and responsibility go hand in hand. You know. Now, 1986, the Act was passed in the Parliament on December 19th, and of course it has got 4 chapters and 31 sections. And there are some consumer dispute redressal fora and some councils. So let us have the understanding of the council. Number 1 is called the central level. It's called CPC, chaired by the Minister of Food and Civil Supplies, meeting at least once in every year, and or SOHS. State level, again state CPC, State Consumer Council, chaired by the Minister of Consumer Affairs, and meet at least twice in a year. District level, called District CPC, chaired by the Collector, meets at least twice in a year. Now let us understand how many forums are there. District forum, State forum, Central forum. And they have their some limits on the financial compensation that they are, which is now of course changed and they have enhanced. So now they say any amount can be protected. But if I have to contest and appeal against your judgment, I can go to the higher court.
Higher court.
First is district forum. The features are 3 members are there. The president is a district judge. The other 2 members are personnel of at least 10 years experience in problems of law, economics, commerce and education and trade. 2 people. Jurisdiction, less than 20 lakhs. But nowadays they can have any amount, even for a district case. The state commission is three members. One is a retired or an active justice of the High Court of that particular state. And of course, 2 other persons of integrity and reputation. National Commission, 5 members. One is a retired or active member of the Supreme Court. And the 4 others are person of reputation and integrity. And so here the limit is anything. But the higher courts are also responsible for taking appeals of the judgment passed by the lower court. So these are the responsibilities of the different types of.
Yeah, but here one of the main issue all the students need to remember is there is nothing called separate Consumer Protection Act only for the patient. It is the it is the general act, and we have to contextualize in this health sections, hospital case. Yeah, because many people may be thinking that there is a separate act for this, separate. Nothing like this. This is a one act for the entire country, and we need to respect this act.
Yeah. We'll define further what is an appeal. Appeals can be made by the complainant to the next higher level, as I mentioned, district, state or central, within 30 days of passing of the order of the lower commission. Within 30 days. And after 50% of the order amount or 35,000 rupees, whichever is there. So you can have an appeal within 30 days. If it crosses that limit, then unfortunately you can't have an appeal. A limitation period, and the District Forum State Commission of the National shall not admit a complaint unless it is filed within the 2 years. Patient has been discharged. So if they have to file a complaint, so it should be within 2 years of service that they have enjoyed or availed or whatever. So that is again a limitation. After 2 years, you remember, that doctor misbehaved and that doctor did not do a good job. That is not permitted. So that is again a feature of 2 years. Enforcement of orders. Every order made by these 3 commissions shall be considered as a degree by the civil courts. So it is comparable to any civil court. In the event of its inability to execute orders of the fora, or the commission shall send such orders to the court within the local limits of the jurisdiction and attach property or make recovery through the concerned collector or dean. So they have the power of attaching your property through the collector. That is the power of the. It's almost the same,
same power like any
other court. Same. Penalties. If the parties fail to comply with the orders made to the fora and commission, shall be punishable with an imprisonment of a period of not less than 1 month to not more than 3 years, and or a fine of 2,000 and less than 10,000. So this is the penalty if you do not follow the orders of the court. Frivolous and vexatious litigation. So there are many very frivolous complaints also. Some patients, just to torture a doctor or a hospital, they will give a frivolous complaint. Any complaint before its fora quorum is found to be frivolous, then the judge can pass an order of a penalty of 10,000 or more, whatever is. Negligence. What would amount to be a negligence? A careless state of mind and recklessness, breach of legal duty to take care, which results in damage, and thus negligence should prove 3 things. What 3 things they should prove? That there was a legal duty of care. If the doctor was bound to provide care, then there was a legal duty to provide care. Number 1, that this duty was breached. Third is, this breach resulted in damage. It could be anything. I mean, you had an emergency, you called for the doctor was duty bound to come. He couldn't come because he was inebriated or anything else could have happened. And that resulted in damage to the patient. That will amount to negligence. Reasonableness means with that competency of 5 years or 10 years, he provided care. Was not immaculate, was not perfect, but that is not negligence.
Negligence, yeah. Yeah, maybe in a particular geographical situation, only
Yeah,
one
yeah.
MBBS doctor is there.
Yeah.
His competence may
Yes,
not be
yeah.
like a surgeon.
Absolutely.
So
He provided care.
Yeah, he provided care, but it cannot be compared
No,
with
it
that
cannot
one.
be.
So this
In
is
that situation, he could do his best.
best. Yeah. And in fact, these days, particularly I am from Tripura, so I often observe that in many interior part, even MBBS doctors, they are doing best
they're doing
care
a
to the
reasonable job,
patient.
good job.
Yeah.
So, what is a medical negligence? Medical negligence means a failure on the part of the doctor by not acting in accordance with the medical standards in vogue, which are being practiced by a prudent doctor practicing the same profession. Both of us are same qualified, same competent, but you are more prudent than me. So, I am not probably practicing the same prudence in my service that I provide to the patient. Now, let us understand what will the medical negligence is basically in three types. One is civil, second is criminal, and infamous conduct. Civil, we have understood that it is a complaint, compensation, and complaint for compensation. That is what. Criminal, you can have IPC, causing death due to rash or negligent act under the Indian Penal Code. Infamous conduct, negligent, drugs, or failure to listen to the complaints, negligence, exposure to risk, negligent advice, inadequate supervision, etc. fall into this category. So these are types by which, the nature and manner of service delivery was also mentioned. So people can twist.
They complain.
Yeah, there are some gray areas which probably would be there, like any other law.
Any case.
Yeah. Now, how to file a complaint? Let us see. No fee, very simple. The complaint shall contain the following: name, address, description of the complainant, name, address, description of the opposite party, facts relating to the complaint and where and how it arose, documents in support thereof, relief the complainant is seeking, and it should be signed by the complainant and can be sent in person or even by speed post, or 6 copies to be filed. 6 copies. I think now, I don't know whether they're taking it electronically, but I guess, it will be there. Now, there are many debatable points, like you asked, which services are free. Let us discuss some points of such nature. Services rendered free of charge by a medical practitioner employed or attached to a hospital, where such services are rendered free of charge to everybody. Like I gave the example of Coal India, public sector hospital, NALCO, Coal India. Nobody is charged a penny. There is no parking fee also. Now, in the same complex, if somebody is charging 10 rupees as parking charges, then you are liable for within the ambit of the act. You are providing free services, but there is a guy who is charging parking. Then, unfortunately,
Maybe registration fee.
No, so in these organizations there is no registration fee.
Yeah. No.
Even registration fee. Yes, that is also, because
I may be not taking money, but some investigation.
No, that is coming for charge.
Charge service.
Yeah, that is charge. Services provided by any non-government hospital or nursing home where no charge is taken from any person and all patients, rich or poor, are provided free services, falls outside the purview of the service. Payment of token amount for registration purpose only will not alter the situation. Your question is answered. Even if you take 10 rupees, you will be under the ambit of the law. So, so now even who are giving religious organizations like Gurudwara, temples, they have a dispensary, they have an X-ray machine, so they are taking money. They are taking a registration rupees of 20 rupees or something, and for the X-ray 50, ultrasound 200.
Even they belongs to under this act.
Yeah. Everybody. Services provided by a non-government hospital where charges are required to be paid by persons who can pay and persons who cannot pay are rendered free services will fall under these services. So if you take 10 rupees as parking or registration, you will be under the ambit of the law. Okay. If no charge whatsoever is taken from anyone and all are treated free and such services fall outside the purview of the CPA, payment of token amount will not alter the situation. If some charge is taken from the patients who can pay another. So this we have discussed, no? Okay. Where a part of the conditions of a service, the employer bears the expenses of medical treatment of an employee and his dependent, this would not be free of charge and fall under the CPA. Supposing, I give you an example, whole India patient, empaneled hospital is Apollo. Okay? So this patient was paid by his employer, which is called Coal India, and things happened in Apollo Hospital. So
they will belongs to this CPA. Under CPA.
Yeah. The patient is not paid, but his employer has paid.
Yeah.
It doesn't matter. You have been paid for your services, na?
Yeah.
So, yeah. Now, these are some little connotations that we all have, but they're very long legal terms. I don't know whether it will be right on my part to discuss them. Let us understand the basic changes that were mentioned there. They have now widened the definition of a consumer. The definition now includes any person who buys any goods, whether through offline or online transaction, electronic means, tele-shopping, direct selling, or multi-level marketing. So he or she is a consumer.
Yeah.
Now,
even this teleconsultation.
Yeah, it is. Because you are paying for that. You are paying for that. Enhancement of territorial jurisdiction. The 2019 Act now provides an added advantage to the consumer by providing for filing of complaints where the complainant resides or personally works for gain as against the 1986 Act, which only provides for filing the complaint where the opposite party resides or carry on the business. This would help in removing the difficulties faced by consumers in seeking redressal of their grievances against any business who may not have an office or branch in their state. So from any place you can file a complaint electronically.
Yeah.
Revised precautionary limits have been fixed under the now Act. Accordingly, the district forum can now entertain consumer complaints where the value of the goods and almost 1 crore, which we mentioned is 20 lakhs. Now it can go to 1 crore. So these are the changes which I was telling you. It can go to any limit. And you have heard of some judgments where the hospital had to pay almost 3 crores for it. Somewhere in Calcutta, somewhere in Pune, and things like that. The state commission shall be, now it is going to 10 crores. That is the power of the state commission. And for the national commission, it is for 100 crores. Huge amount.
Yeah.
So we can have some alternate dispute resolution. Another provision introduced by this 2019 Act, because it was amended in 2019, to ensure speedy resolution of disputes is to provide for referring the disputes to for mediation. Like in arbitration, we have arbitration. So in arbitration, it has got the same power. Judges retired from the Supreme Court or the High Court are usually the arbitrators, and there's dispute between two of us, and we can select a group of 5 arbitrators, and then we have to agree to one arbitrator. Same power they have as a High Court, same power. The same thing applies here also. So they can ask for a resolution. Aapas mein aap log, you can discuss amongst yourself and find out a resolution. If it is, if no, then it will proceed the way it is.
I think that may lead to the faster decision.
Faster, yeah. So same applies in arbitration also. It is the same as in a court of law.
Yeah.
There is no change. Only thing changed was that recent times was the online, So that was the only change. E-complaint. So in internet you can have an e-complaint. This also provides, this 2019 provides for filing of complaint before the district forum electronically in accordance to the rules which are now to be prescribed by the government. So you can do a filing of them. Manually we had to give 6 copies. So now you can send it by email.
Yeah.
So e-filing of complaints. The new act provides flexibility to the consumer to file complaints within the jurisdictional consumer forum located in the place of residence or work on the of the consumer. You can do either there locally, or you can do from other states also. It doesn't make a difference which was electronical now. Well, establishment of a Consumer Protection Act authority. The new act proposes the establishment of a regulatory authority known as the Central Consumer Protection Authority, with wide powers of enforcement, which was mentioned. Enforcement agency could be the collector, the police, or whatever. The CCPA will have an investigation wing headed by a Director General, which will conduct inquiry on investigation to consumer law violations. DG Police.
Yeah. Actually, in Indian context, many times it was observed like there are many rules and regulations, but there is no enforcement capacity of the particular things.
Yeah, so there are newer development which they have now went for the yeah, because people have to be fearful or afraid of law.
Yeah.
If they are not, then I think we better have some enforcement. Or
else, once I was talking to one of the lawyer of this Medical Council of India. So they said that we are regulatory body. We are not enforcing. So
they are regulatory body. Yeah.
So like this, many places, even they know that this is not going correctly.
Yeah, they can't do it.
They can't enforce it, reinforce it.
That's right. The CCPA has been granted wide powers to take suo motu actions, recall products, order reimbursement of the price of goods and services, cancel licenses, and file class action suits if a consumer complaint affects more than one individual. So that is the power that they also have now. Now the other changes that we will have is the term product seller is defined to include a person who is involved, but this is not applicable to hospitals. These products are general amendments in the act of the, as you asked me whether there is a separate act for healthcare. No, it's the same act.
Same act.
Yeah, but there are some changes which are not so much applicable to the hospital. Unfair trade practices. The new act introduces a specific broad definition of unfair trade practices, which also include sharing of personal information given by the consumer in confidence, unless such disclosure is made in accordance with the provisions of any other law. So your personal information is being used for some other mala fide objectives or intentions. So that will also be a part of the
data security they are talking about.
Right. So penalty. So you can have a penalty for misleading advertisement against any person, or CCPA may impose a penalty up to this is how much is 10 lakhs.
10 lakhs.
On a manufacturer or an endorser for a false misleading advertisement. So they can have a penalty of 10 lakhs. I may sentence them to imprisonment up to 2 years. There's some additional powers and amendment that has been the endorsement of liability. The new act fixes a liability to endorse, considering that there have been numerous instances on the recent past where the consumers have fallen prey to unfair trade practices under the influence of celebrities acting as brand ambassadors. This has been a common practice for advertisement, or I don't know what to say, to create gatherings, or for any purpose, doctors included.
Yeah.
In such cases, it becomes important for the endorser to take onus and exercise due to diligence to verify the veracity of the claims made by the advertisement to refute liability. The brand ambassador. So, brand ambassador, for the lure of money, there's a script he or she has to read. But the people reckon him with that particular brand. If something goes
wrong... So, even brand ambassador is also liable under this code.
That is what it is. Doctor-patient contract requires that the doctor must continue to treat such a patient, and responsibility begins when he first sees the patient in the OPD or emergency or anywhere in the clinic. Provide reasonable care, uses clean, proper instruments, write clear prescriptions, give full direction to the patient as regards use of drugs, and must suggest, insist on consultation, investigation whenever needed. Some do's and don'ts. Do's are always write date, time of consultation on part of the doctor. Mention age, sex, weight of the child. Complicated cases, mention precise history and physical findings, including negative findings. If patients' attendants are erring on any account, write a note of it, and if they refuse to any consultation or direction, seek a written refusal or make a note of it.
Yeah, actually, particularly in northern India, many times it was observed that women is not ready to get examined by the male doctor. So the doctor may refer it, okay, you go somewhere where female doctors are available, but it has to be on the note. Like doctor must write that patient refused to examine. Otherwise, if on the way something happened, they will totally blame to the doctors. That doctor has not done anything. That is the reason my wife died. So something.
Mention condition of the patient in specific terms and avoid vague terminology. Record history, drug allergy and complications. Write drug name, dosage, method of administration very clearly and prefer in block letters. Mention additional precautions with diet, rest, avoidance of alcohol. Mention if prognosis is explained to the patient's attendants. Write in the local language as much as possible. In case of deviation from the standard practices, mention the region's special consent for sterilization. Even if the if wife has to be sterilized, the consent has to be, informed consent has to be given by the patient, not by you, but sometimes by you as well. So those are some little issues. Specifically mention SOS review, follow-up schedule, date and time, etc. for proper communication. Mention if the patient is under the influence of drugs. Special attention to emergency cases, especially children, anesthetic and complications. Respondent superior. So if a junior of yours does some mistake, you are responsible. So that is meaning of respondent superior. Operation on wrong limb, digit or eye or tooth. So now the respondent superior can be the hospital also. So then the doctor, if the lawyer is good, then he can shift the responsibility to the hospital, telling that the hospital directed this doctor to do it. Situation can little change. Always take special precautions in MLC cases. Always advise X-ray in case of bony injuries. For nurses, take proper consent, carry out order, because the complaint can be against the nurses also. So take proper consent, carry out orders properly, count sponges after or before the surgery, safe injection practices, inform the doctor during crisis or any problem, maybe administrative and supervisory role. Some don'ts, for the medical practitioners. Don't hesitate to discuss the matter with colleagues and peers, even patient attendant or patient. Do not write Ayurveda and homeopathic formulations. Leap 52. Do not allow any substitution by the pharmacist. Don't examine the patient if you are sick, exhausted, or under the influence of alcohol. So that is in a nutshell that we had to discuss, unless we can.
Yeah, actually this area is quite grey, particularly a country like India, where we do not maintain the proper medical record. And this may be the one of the weaker part of this maybe per se act, or maybe you can say the advantage is many of the patients are not aware about this consumer act or the benefits of this act. But I think gradually the healthcare cost is increasing only because of they need to maintain a proper record, and they also need to face some kind of allegations, wherever there are some kind of situations.
I feel there are record keeping is there, manually or electronically or HIS or whatever. But the problem is the healthcare providers, they are not updating their record. They are not documenting their findings. They are not documenting the clinical stuff which could have saved them in an event of a crisis. They think it's given. So those medical record department will be there, may not be there. In certain places they have HIS. The hospital probably encourages the doctor to enter all the findings onto the HIS. They don't do, So these are some situations, I don't know whom to blame, but what happens is there will be a medical record most of the time the history is not written. Many times, almost 80% times, the follow-up examination and the daily rounds are not documented. Worst case scenario is OT notes are not documented in the real time. So if they have a medical record department, but absence of qualified and competent medical record technicians or officers, HIS may not enable the doctors, even if they do enable, the doctors do not type or they don't have the
maybe
habit of
organizational behavior need to change.
So these are some nuances which probably our medical fraternity should be also be doing so as to safeguard themselves and also the hospital. Yeah, medical record, the habit of not documenting is a problem.
Yeah. So here the changes of behavioral, like organizational behavior, proper
it needs,
training.
because organizational behavior is one, but somebody thinks they know it all and it is beyond their dignity to document or write or So those are some societal changes which I told in the beginning.
Yeah.
That these things, materialistic changes, societal changes, cultural practices to be changed. So there are many factors which have resulted in this kind of situation that we are in.
But sir, here I think one issue we need to also discuss, although it is not purely under this Consumer Protection Act, but if somebody is supposed under the allegation of the negligence, whether it is affecting his medical council good standard certification process or his licensing, how much it is affecting?
Now, MCI, as you rightly said, is a regulatory council, now National Medical Commission. Now, well, these are situations where an act of omission or commission has resulted into this kind of complaint. A complaint will be a complaint unless, so till the courts prove that he has to be compensated, so then it becomes under the Consumer Protection Act. If filed under the IPC, then it will take a serious turn because the smallest example is the permanent disfiguration pursuant the surgery which the doctor did with all good intention, but figuratively it was damaging. So then, it will become IPC. For medical NMC to act on this may not be the right thing because every prudent doctor or provider will do according to the best of his ability and competency. Situations can go wrong or things, no two patients are same. So some would heal faster, the others would not heal faster and probably take a couple of months to heal and then would eventually lead to a scar or keloid or stuff. Keloid is something again a disfiguration.
Yeah.
So then what do you do? So I have my own doubt, but the NMC would not have a role. Either it will be a IPC or Consumer Protection Act.
Okay. So I think, here I think for the same applicable for the doctor as well as nursing also.
Right. Yeah. When you asked was that in India, in developed countries, so to say, the awareness has gone up to the roof. So much is the case now. This generation, which is mostly onto this internet and all, because things are so. So nowadays the situation in India is also earlier for maybe a couple of years back, the number of cases in the consumer protection was not too much. Maybe around 3% or 4%. But maybe now it will increase with the awareness coming in and creeping in the same level of developed countries.
Yeah. So I think we have discussed the almost all dimensions of the Consumer Protection Act, particularly in terms of the healthcare institutions or hospitals, and particularly here we need to make that if your intention is good and if you follow the proper procedures as per the standard guideline, then you cannot be at fault. The situation may go wrong, but this is what sir is also saying, but we can protect our own. So protecting our own is much more important than the protecting others.
Yeah, that protecting ourselves is yes, doubly we shouldn't have that indemnity. Employers insist for 20 lakhs, but you saw cases have gone and where
Yeah.
the compensation was given for 3 crores. So now the courts also have the powers to go to 100 crores.
Yeah.
So we are at a loss. How much of indemnity shall you?
Yeah.
Because you have to pay the premium. So which is okay. I mean, premium is a small price as compared to that damage eventually that might you can encounter. So I would say yes. Even if you need to be a little indemnified.
Yeah. So I think we have to be very careful and respecting our own professions and following the standard procedures. These are the bottom line message. So that we should be staying away from all other things. But in the meantime, we must be aware about the all nitty-gritty part of the rules, regulation and act. And many times it is updating. Like people who read in 2016 and they think that, I read this act, but in this meantime it is updated in 2019. So maybe another few years it may update again. So we need to keep updating ourselves in terms of the changing scenario. So I hope all of you understand this topic very well, and you will oblige to respect these rules and regulation in your day-to-day practice. And here I would like to say thanks to our sir, Dr. Bidhan Das, and thanks to the students who are viewing, and thanks to the team of EMPC who is helping us to broadcast this program. Thank you very much to all of you. Thank you. Namaskar.